This video is all about LGBT discrimination at work. California employment law prohibits sexual orientation discrimination. But what does it look like? I'll explain everything that you need to know, so stick around. California Fair Employment and Housing Act can be found in the Government Code, Section 12940. That is the main anti-discrimination and anti-harassment law in California that applies to employment. Subsection A deals with discrimination and J deals with harassment. A basically says the following: it's an unlawful employment practice for an employer to take any adverse actions against an employee due to his or her sexual orientation, gender expression, or gender identity. You're not allowed to do it. Okay, subsection J basically says the same thing, except it says you're not allowed to harass somebody because of their sexual orientation, gender identity, or gender expression. Well, what do those three things mean? They're defined. Section 12926 of the same Fair Employment and Housing Act, subsection S, defines sexual orientation. It says heterosexuality, homosexuality, and bisexuality. You're not allowed to treat somebody poorly or take adverse actions against somebody because they're straight, or because they're gay, or because they're bisexual. It's pretty simple. But gender expression, the definition, can be found in a different area. Under subsection R, under the definition of sex, includes gender expression. And it is defined as follows: a person's gender-related appearance and behavior, whether or not stereotypically associated with the person's assigned sex at birth. So you can't discriminate against somebody because they're lesbian, gay, bisexual, or transgender. Now that we got the lawyer mumbo jumbo out of the way, what does this actually look like? Well, under the discrimination law, you can't take adverse actions against an employee. That means an employer can't terminate you, refuse to hire you, demote you, cut your pay. They can do those things to you, but they can't do them to you because you identify as lesbian, gay, bisexual, or transgender. They just can't do it. So long as they have more than 5 or more employees, they're not allowed to discriminate or take these types of actions against you because you identify in the LGBT community. California's anti-harassment law basically says the same thing, but as opposed to adverse actions like terminations, demotions, pay cuts, it's all about the company treating the employee poorly or coworkers treating the employee poorly. So a coworker or a supervisor can't call a coworker names because they identify with one of these groups, make offensive gestures. That's so common in these types of cases. Send terrible text messages or emails about the employee or to the employee because they identify with one of these groups. At the end of the day, if you feel like the company, your manager, or your coworkers have created an abusive working environment, make sure that you contact a lawyer, because if that behavior meets the definition of a hostile work environment, which is what subsection J of the FEHA law is all about, then you might have a case that's worth pursuing. Because if you've been discriminated against or harassed, then you're entitled to monetary damages, which we'll talk about at the end of the video. So at the end of the day, if you are harassed or discriminated against, just contact a lawyer. Now that we know what these cases look like, let's look at an actual one. There was a case that came out of California. The plaintiff's name was Daniel, and he was gay. He had worked at a company successfully for many years, received pay raises, promotions, accolades, but then he was transferred to a new office in San Diego, and he got a new manager. His new manager was a tyrant. He said things like, "This is no place for faggots. This is not a company for gay people." And the plaintiff complained. He complained about it. He went to HR, but they didn't do anything about it. So he went on a leave of absence. And eventually, the company just thought that he abandoned his job and sent him an official termination letter. Well, not only is there a harassment component to this and a potential discrimination case because he was terminated, but there was an issue as to whether or not the employee was fired or if he abandoned his job. And the lower court judge thought that he had simply abandoned his job and threw the case out. But Daniel was smart. He appealed, and he prevailed on appeal. The upper court said that there are tribal issues of fact, and this case can go before a jury. Now, I don't even know what the financial outcome of this case was. It probably settled. But there are significant damages that people go through when they're either discriminated against or harassed due to their sexual orientation. If you prevail in your sexual orientation discrimination case, you can first win your economic damages. These are lost wage damages. So if you were working at a company making $75,000 a year, and then you come out of the closet and you tell your boss, and he fires you because he doesn't like that you're a member of this group, then you're not making $75,000 a year anymore. That's a very tangible economic loss that a judge and jury can measure. Likewise, if you win, you can win emotional distress damages. These are the damages for the mental pain and suffering that somebody goes through as a result of being victimized because of their sexual orientation. These damages are very real, and most people minimize them in society, but when you really dig down, these damages have catastrophic impacts on people's lives, and they can't be minimized, often the largest component of these cases. Third, if you prove your case with malice, oppression, or fraud, you can win punitive damages. Now, most people have heard about punitive damages. The damages meant to punish the defendant for acting so atrociously. They're trying to deter the defendant from ever doing it again. Well, those damages, while powerful, are very rare, and they're really difficult to win. But if you do find a really good employment lawyer, they are more likely to ring that bell than just mediocre employment lawyers. So make sure you spend a lot of time trying to find the right lawyer for your case. And finally, if you win, you can also win attorney fees. Attorney fees generally go to your attorneys, but the reason why I mention them here is because they can be substantial, and they often are so large that they push the company into trying to come to the settlement table earlier rather than later. So they give you good bargaining leverage. Anyway, I hope all these damages make sense. I hope this video is helpful, and I hope you have a great day.